Afternoon, everybody. Thank you all for coming. Appreciate the turnout. So we were here last year, and we tried to sort of give everybody a very broad overview of intellectual property and how it applies to Amazon. This year, we tried to focus a little bit more on the needs of the private label sellers. And we keep seeing the same issues over and over again. Is that you have a new product, you're selling it, all of a sudden you realize somebody is knocking you off or taking advantage of your trademarks. And you come to us and you say, what can I do to stop this? And in many cases, without the preparation, without all the advanced planning, it's very difficult. So what we're going to talk about today is how to build a portfolio of IP in a cost-effective manner, and in a way that specifically can be enforced on Amazon. Amazon provides a certain number of tools that are that you can take advantage of. And we're going to talk about specifically how to tailor your IP for those tools so you can easily get rid of hijackers, infringers, when the time comes. So we'll just briefly, we'll go over the different types of intellectual property. We'll explain how you can, again, how to build a portfolio that's based on Amazon. What's interesting about Amazon is just how much it's changed things, enforcement overall. Not just for what you guys do, but for how we practice. You think of in the non-Amazon world, you find somebody is infringing on your rights, somebody's knocking you off. You see the infringing product in a store, and you think how do you take action? Usually that involves trying to figure out who the manufacturer is, writing letters through lawyers and litigation, and all these things, which take many years and cost, in many cases, hundreds of thousands of dollars. And that tends to favor those with the bigger companies, deeper pockets. In a lot of ways, Amazon has leveled the playing field in that smaller sellers, if they have the right types of IP, can be in the same position as the big companies, where everybody's in the same position, everybody's filling out the same forms and asking Amazon to take down the infringers. So it presents a really unique opportunity for you guys, and it really changes how we practice law. But to take advantage of all these ways, all these tools that Amazon offers, you have to have the right type of intellectual property. So we'll go through the different types, the main types of IP that you can register and build, just so everybody's on the same page. And we're going to spend a lot of time talking about trademarks. I'm sure a lot of you are familiar with trademarks. A trademark could really be anything that identifies source of goods. So it could be, the things that we're used to seeing, the Coca-Colas and Toyotas, things like that, a word. But it could also be anything else. It could be a sound, a color, just about anything. For e-commerce purposes, for Amazon, the typical words, that's what we're going to focus on. Because it makes sense. That's the easiest type of thing to enforce. Logos and things like that can be very difficult for Amazon to enforce, because they're not text-based. Second type of IP is patents. There's really two types of patents. There's utility patents and design patents. When most people think of patents, they tend to think of the utility patents. They cover how things work. A better mousetrap, a new type of building toy, some sort of computer process, things like that. And utility patents we'll talk about a bit more later. They certainly have value, but they're not always right for e-commerce sellers, particularly Amazon sellers, because Amazon doesn't always want to enforce them. They are very complicated. So we're going to spend a lot more time talking about design patents. Design patents cover how things look, the ornamental aspects of your products. Here's some examples. You have a particular type of frying pan that has different compartments for different cooking different food, particular shape of a bottle, and packaging. A lot of people don't realize you could take advantage. You get a design patent on packaging, and when somebody knocks you off, they tend to knock you off, lock, stock, and barrel with the packaging and everything. And if you have a simple design patent on how your packaging looks, you can easily get rid of them. And the third type of IP is copyrights. Copyrights cover the artistic expressions, original expressions of ideas. So it's all of your text, your Amazon listings, all the text that you worked hard to write up to come up with something unique. That's all protected by copyright law. And all of the photographs on your listings, all protected by copyright law. If somebody steals your pictures, it's very easy to get rid of them and shut down their listings. The content of your web pages, the same thing. So we'll circle back and we'll talk more about how to take advantage of these things. So trademarks. It all starts with choosing the right mark. If you choose a strong mark from the beginning, it will make your life much easier down the line. So you might have seen something like this before if you've ever looked into trademarks. This is it's sort of a continuum. You have very weak marks on one end and you have very strong marks on the other. The strongest type of marks are words that are just completely made up. Exxon, Xerox, Kodak, those words, whoever came up with them, they just pulled them out of thin air. They chose them because they were easy to say, easy to spell, and for no other reason. So those types of marks, completely made up words, those make the strongest trademarks. The second type of strong mark, we call them arbitrary marks. Something like Apple for computers, it's just sort of meaning, the word applied to the particular goods is just completely meaningless. BlackBerry for mobile phones, Starbucks for coffee, it just doesn't mean anything. And if you pick a strong mark from the start, it'll make it easier for you to obtain your registration when it comes time to file it. It'll make it easier for you to enforce your mark down the road. A lot of people sort of take the easy way is they pick something that's descriptive, speedy delivery service, Sharp Knife Co. You're only going to have more problems. I know it's hard to come up with a good name, but do yourself a favor, come up with a strong mark from the beginning, and it'll save you money, it'll make your life easier. Keep in mind, as you are looking for a name, just because somebody's using a name for one type of product or one type of service doesn't mean you can't use it for a completely different type of product and service. This was 3 examples: Domino Pizza, Domino Sugar, Domino, I think it was a chain of fast food places or something like that. They all can coexist in the world just fine without any issues because they're all in different, marketed to different goods, so applied to different goods. So it's not a problem at all. And when you're choosing your trademark, your brand name, at the same time, you're going to want the corresponding domain name. You're possibly going to want the corresponding, Amazon seller name if you can get it. It's not as critical, but it's nice to have. So make sure all those things are available from the beginning. Especially the domain name. For Amazon purposes, it's good to have the corresponding domain for purposes of showing, copyrights and things like that. And there's other reasons to have it. So keep those things in mind as you're choosing a name. Now you've decided on a name, what's the next step? The next step is to make sure you can actually use it without infringing anybody else's rights. Before you think about registering it, first take a step back and say, okay, can I use this without getting into trouble? And there's really 2 ways, it's 2 types of searches. If you call an attorney, they're going to tell you, basically, I could do what's called a knockout search, or they also call this a screening search, it's a little bit more advanced, or a full search. Just so you understand the difference. A knockout search, basically, we're going to look at what's registered with the U.S. Trademark Office, and we're going to see basically if there's an exact match or something very close to it. And that's all we're going to tell you. In many cases, people are satisfied with that. You have to decide what's worth to you. Only a full search will look at everything in the United States, whether somebody's registered the mark or not registered the mark. It's very possible that somebody's been using a particular brand for 20 years and has just never bothered to go file a registration. That person still has rights, and they have rights that are superior to yours. So there's a difference in cost. You have to decide whether it's worth it for you or not. But again, the only way you're going to know for sure is to do the full search. The test for trademark infringement is likelihood of confusion. You look at the 2 marks side by side. You consider, the sight, the sound, the feel to it. It's not just is it identical. It's likelihood of confusion. So there's a whole bunch of factors that go into that. And if you're not 100% sure, talk to an attorney and get a proper opinion before. It's a shame. We've had so many situations where people spend all this money, they pick a name, they make up their marketing materials, they make up a sign, they start labeling packaging, and then they get a cease and desist letter from another brand owner saying, no, you can't use that, and everything goes in the garbage. And this happens every day. And again, if it would just, it could just be a matter of a few $100s doing the right search, you avoid all of that. Okay, when it comes time, you're past that process, you actually want to go ahead and register. There's 2 types of applications you can file. You can file an intent to use application before you're even using a mark. Let's say you've decided this is something I want, but I don't actually have the products yet. I'm not actually using it. So you can file an intent to use application. That way it gives you priority. It tells everybody that you're going to use it. Or you could, if it's a situation where you're already selling the product, you can file a use-based application. Those are the two main types of applications: intent to use and use-based. The second important decision to make when you're filing an application is whether you want to apply for it on the principal register or supplemental. You always want to be on the principal register. If you're applying for Amazon purposes, for brand registry, which we'll talk about more later, you need to be on the principal register. Principal register is for the more distinctive marks. The supplemental register is for the descriptive, the weaker marks. It doesn't provide as much benefit, and again, for Amazon purposes, it's not worth much. And then, of course, for Amazon purposes, whether it's a word mark or we call stylized mark, meaning the font, the logos, like the Coca-Cola in script, Amazon will accept either one. So when it comes to trademarks, most Amazon sellers are a little bit ahead of the game because everybody wants brand registry. So everybody calls up, they want to know how to get on it. And basically what I said, what you need is, the requirements are fairly minimal. It has to be a federal registration. It needs to be a word or stylized mark. It can't be just a pure logo because Amazon doesn't have any way to enforce that. And it needs to be on the principal register. Okay? We've had lots of cases where people come to us and they say, can you get us on brand registry? And we look at what they did, they did on their own, and they're on the supplemental. I had one recently, somebody called, they did it on their own. The trademark examiner calls them up and says, your trademark application, it looks good, but are you okay putting it on the supplemental? The applicant had no idea what that meant. He said, sure, sounds good. Of course, it's worth nothing on it, for Amazon purposes. As far as brand registry itself, you guys, I'm sure, know the advantages better than we do. It does give you more control over your listing. Lets you keep all the details there as far as what the product features, the warranties, and all that stuff, which is great for you guys. But from our perspective, it does make it easier to remove the hijackers, to police your listings. We use the tools a lot. What happens is our clients will set us up as agents for brand registry. I have my own brand registry account. I can go in and I could do the enforcement for them. And the tools there just make it so much easier than just doing it through emails and letters. There's a clear process in place for escalating appeals when they don't go through the first time, and it just makes everybody's life easier. So at least from our perspective, it is worth it. As far as obtaining a trademark, especially for brand registry, you do have to keep in mind the timing. People come to us and they start selling a new brand and they want to get on brand registry tomorrow. It doesn't work that way. To get a regular U.S. trademark application is typically 6 to 8 months. So one way to avoid that is obviously to file an intent to use application earlier on in the process. That way at least you get the ball rolling on it. But it does take time. So nothing's going to happen overnight, and that assumes there's no major issues and everything goes smoothly. If there are rejections and you need to go back and forth with the trademark office, it can easily stretch out over a year or more. We have a lot of people that, of course, want to get on brand registry quickly. They don't have patience for U.S. trademark, so they file in a foreign country. Germany and UK are popular ones. Germany is particularly fast. The only thing we absolutely make clear is that, yes, in most cases, it will work to get you on brand registry, but it has no other value in the United States. Registering your mark in Germany does not give you any trademark rights in the United States, and if you need to actually enforce, if somebody's infringing, it's not going to help you. It helps, it's worth it for many people who want the brand registry. They want to be able to get control of their listings, they want to be able to report people for doing certain things, not IP related. But beyond that, please understand that you're spending a bunch of money where you're not going to get rights in the United States. And just to point out, in some cases, filing in a foreign country actually does make sense, because if you have a mark that's sort of weak and it might not be registerable in the US, some countries are a little bit more lenient as far as accepting descriptive marks. So it does make sense for some people. Just understand the pros and cons. Another question that comes up a lot now, again, people want to get on brand registry quickly. They say, well, why can't I just buy a mark from somebody else who's not using it? Buying and selling trademarks is a lot more complicated than other types of intellectual property and other types of property in general. Because if you think about what a trademark is, it's your goodwill of your business. It's your whole reputation sort of wrapped up into a word. And if you try to buy that without the underlying business, without the underlying product line, it can often be worth nothing. In the United States, the law is very clear that if you have a trademark assignment from one party to another that does not explicitly say that it includes the goodwill of the business, it's worth nothing. It's invalid as a matter of law. So, and the same thing, lots of times, if you're considering buying a mark from a company that's gone out of business, it's very possible that under the law that mark has already been abandoned. Even though the trademark is still active, and it's been renewed, it's possible that several years have gone by and nobody's been using it, and at this point, the mark might not have any legal value. So you do have to be careful. The point is, before you spend any real money on buying a trademark, have somebody that knows what they're doing look at it. If you're buying the whole business or a product line with a going line of products under it, that's usually not a problem. It's just know the signs. If you see these companies went out of business and they haven't been selling this stuff in a while, just keep that in mind. Another issue that comes up is a lot of sellers, I think, once they get brand registry, their trademark work sort of ends. They sort of forget about the whole thing. But that's not a good idea. I think trademarks, you have to constantly reevaluate. Each time you add a new product, consider, should I file a new registration to cover it? If I add a new product line, do I want to, with a new brand or a sub-brand, consider filing another trademark application to cover it. And also, as you, let's say, change your logos, that's another issue. Like if you've registered your logo and you change your logo, you're going to have to consider filing another application because your first one might not have any value anymore. And once you do have those rights, Amazon makes the enforcement straightforward. This is right off of the brand registry interface. There's different types of infringement that come up. It could be right on the product page. Somebody's, let's say, using your trademark to steer traffic to their listing. Fairly easy to take them off. Once you've gone through the brand registry process and you have your registration, that's the simplest type. In some cases, somebody's actually putting it on their product itself, again, or they're just knocking you off entirely. It's a counterfeit product. These are all things that are fairly straightforward in enforcing on Amazon, particularly, but you need to have the registration. Trying to do this process without the registration, just using what we call a common law mark, is difficult, and lots of times it just doesn't work. Another tool that a lot of brand owners aren't taking advantage of is U.S. Customs. You can, in many cases, stop the products before the infringing products before they even get to Amazon's warehouses. U.S. Customs and Border Protection makes it very easy for anyone with a registered trademark to record their mark, and that way it's inside of every single computer at every single port of entry. U.S. Customs is a lot more sophisticated than many other government entities. They actually have modern systems. You can provide them with detailed information, how to spot the fakes, how to spot counterfeits, and they'll really work with you and help you out. And it's a great way to eliminate the issue before it comes to the point where the products are already being listed on Amazon, they're already in the warehouses. You stop them right there at the port and you don't have to worry about it. This is extremely inexpensive once you have and there's too many people not taking advantage of it. You register, you renew it, it's good for 10 years for very little money. There's just a no-brainer. Some issues for private label sellers, particularly on the infringement front, that we see come up a lot. If you're developing your own product and doing your own packaging, and you're controlling the whole supply chain, it's not really an issue. But if you're buying from another manufacturer branded products and you're either repackaging them, that comes up in two ways: either taking their products and incorporating them into some sort of product bundle, or you're buying in bulk and breaking it down and selling it in smaller quantities. The original brand owner might not be happy with that, and they could go after you for trademark infringement, depending on whether you've put the proper language on your packaging and to explain that you're repackaging it or not. So it's just something to keep an eye out for. If you are repackaging, bulk products, things like that, consider whether there's a trademark issue. The same thing for rebranding goods. If you're buying somebody else's, pre-branded product, you're taking off their brand and putting yours over it. There is a potential trademark claim that somebody can make. They call it reverse passing off, where you're sort of taking advantage of all they've built and basically the hard work that they've done. But a lot of that, all these issues can be avoided if you just have these conversations with your distributor beforehand and tell them exactly what you're planning on doing. In many cases, they won't care. They're happy to sell products. But again, deal with these things ahead of time. And okay, we're going to move on to talking about patents for a little bit. So you have typical person, you have an idea for a new product, something like that. There's really two things you want to do before you go ahead and launch a product. And one is you want to make sure that it's free to use. We call that a clearance or a freedom to operate, meaning you can go ahead and sell the product without being sued. Once you've gotten past that step, the next step is, can I get my own patent? So we call that a patentability search. So those are the two types of searches, if you go to a patent attorney, that they're going to ask you about. It's clearance and then patentability. And they're looking, when you do a clearance search, you're basically just looking to see if there's an active, in this case, US patent that will cover the product. You're not worried about whether there's expired patents or things like in other countries. You're only worried about, is it clear to use? Is there something active that's going to stop me from doing this? In terms of a patentability search, can I get my own patent? It's a lot broader, because any other disclosure, it could be in a foreign country, it could be anywhere, that can bar you from getting your own patent. And I was talking about this a little bit earlier. If you were to come up to me or Tuvia, 10 years ago, and you would say, I have this new product, our initial reaction would be, you need a utility patent. That's what most people, sort of associated with inventions and technology. For Amazon sellers, you have to think, does that really make sense? For a few reasons. The cost is significantly more than design patents and other types of IP protection. When you file a patent application, it's the start of a very long process that takes many, many years. It's a lot of back and forth with the Patent and Trademark Office. And you have to think, does that really make sense in terms of the design cycle and the life of a typical product? If you have a product that's that you're only planning on selling for a year or two, this wouldn't make any sense. So, and the other issue is that Amazon doesn't like to enforce utility patents. They're rather complicated. They require a lawyer. So in most circumstances, Amazon won't take action. They'll just say, you guys go work it out on your own. So again, these utility patents really have a purpose. They have a place. But for a lot of private label Amazon sellers, they really don't make sense. This is an example of what Amazon tells you to do when you file a utility patent report. They say, you guys go contact each other and try to figure it out. They usually won't take action. So design patents, I think at least for private label sellers, can be a lot more valuable. They're relatively quick. You can get them in about a year and a half. There's a little bit extra cost. You can expedite the process. Compared to utility patents, they're fairly inexpensive. And Amazon won't readily enforce them. Because if you think about a utility patent, we're going to look at some examples. It's just drawings. I mean, anybody can look at the drawing against the product and make a decision. So because the process is simplified, you file a report the same way you would file a trademark or copyright report, and Amazon will usually take action. With design patents, and again, we'll look at some examples, the drawings are everything. So they need to be perfect. They need to show every angle, every aspect of the design. And you can choose, again, we'll show you how, you can choose what you want to claim versus what you don't want to claim, and what you consider part of your invention. So these are two examples from two design patents. And for design patents, the most important thing is what's in solid lines. So what's in solid lines, you're claiming it as part of your invention. And that means that for somebody to infringe your patent, that portion that's in solid lines has to be very similar. The ordinary observer has to be able to mistake those parts. So if you look at there's two teapots here. So the one on the left, that person chose not to claim the spout. They chose just to claim the body and the handle. So if you were to put a different spout on that same teapot, it would still infringe this patent because the spout is not claimed. Only the body and the handle are claimed. If you look at the one on the right, it's the opposite. That person has chosen to claim the particular spout and not claim the handle. So for somebody to infringe, they would need the exact same spout, but they could have a different handle. It's fairly simple, and that's, as long as you remember solid lines versus dashed lines, you're all set. Here's some more examples. So like on the left, we have a teddy bear, but this person chose not to claim the head. They chose just to claim the body. So that doll could have a completely different head on it. It could have the head on the right that you see of the elephant, and it would still infringe this patent. The drawing on the right is the opposite. They've chosen to claim the head, this elephant head, but not the body. So as long as somebody uses that head, they would infringe. And there's a lot of different strategies for filing design patents. In this case, somebody chose to file one patent, the one you see on the left, just covering the top of this computer desk, and then they filed a completely separate patent on the right, filing the base. That way, if somebody copies the top or they copy the bottom, you're going to catch them. And there's all kinds of different, again, more strategies. You can file one application, and before it issues, let's say a year and a half later, you can file what they call a continuation application, which is claims similar subject matter, but leaves out certain things. So let's say, I'll use this example. It's some sort of industrial mixer. If you look at the one on the left, it's actually claiming there's a pipe on the bottom that's in solid lines. So let's say a year later, you realize that your competitor is making almost the identical product, but they don't have that pipe on the bottom. They've eliminated it somehow. So you file a new application, look at the one on the right, that actually dashes out that pipe on the bottom. So now you can catch your competitor with that one without having to start over the whole process. A lot of people don't realize you can also file design patents on packaging. These are two from actual patents. To be honest, I couldn't believe that somebody actually got some of these because it's just so ridiculous that you can get a patent on this. But you can go ahead and do it. Again, somebody's going to knock you off. They're going to copy the whole thing, the packaging, the product. It's really just an inexpensive way to protect your brand. Patents, things to keep in mind, you have to be an inventor, or you have to be able to name the inventor. So if you're just buying something from a Chinese vendor, you don't know who created it, you really can't file a patent unless you obtain all the rights to it. You can't just say, okay, that's mine, I'm going to go file a patent. You need to actually be the inventor. You're going to have to sign an oath saying that you're the inventor. Patents have to be filed within 1 year of the first sale or public disclosure. If a patent is not filed in that time period, it's barred forever. You're never going to be able to do it. That's completely different than trademarks and copyrights. Trademarks, you can use a mark for many, many years and then wake up one day and say, oh, okay, I want to register it. Same for copyrights. Patents, you get this one shot. After that, forget about it. Patents, you have no rights until it's actually issued by the patent office. While your application is pending, patent pending, you have no legal rights. A lot of people, you'll see that they'll put on a listing, we have patent pending. It really doesn't mean anything. It might have rights in the future, but right now you don't. Jump over to copyrights. Copyrights also, not enough people are taking advantage of filing copyright registrations. They're ridiculously inexpensive, and they give you so much protection for just very little money and very little effort. Like I said, copyrights, as soon as you create something, whether it's your web page, your product listing, photographs, they're protected by copyright law. But by registering them, there's additional benefits, and it gives you additional damages awards. It entitles you to attorney's fees in litigation. But as we'll talk about after, it makes it much easier to enforce on Amazon. You put in your registration number, and Amazon takes it off and takes off the infringer, and you're done. So the things to keep in mind: you're listing photographs and the content. Interesting thing, a lot of people don't realize about photographs. For example, you hire somebody to do photographs at your wedding or bar mitzvah. Who do you think owns the photographs? The photographer, right? A lot of people don't know that. They think that, oh, I paid the photographer, I own the photographs. It doesn't work that way. The copyright stays with the photographer unless you agree otherwise. So a lot of people, they hire somebody to do the photographs for their Amazon listing. Who owns them? And then, when it comes time to register them, you can't do that unless you have all the rights. So work that out ahead of time. In most cases, the photographer is not going to care. they're going to, they'll assign you the copyrights at the same time. But you need to do that, at that time. You don't want to go chasing down your photographer, a year later when you got to go file your copyright application. And the same thing for your listing content. All these things can be registered. It's fairly straightforward. Besides the photographs and the content itself, in some cases you can actually get copyrights on the products themselves, but it needs to have some artistic expression that's separable from the product itself. So you see this in a lot of cases with like statues, plush toys. These things have artistic value beyond just the functional aspects, beyond just being toys. There was some artistic element to them. And in those cases, like I said, plush toys can be protected as sculpture. It's very common. Toby has a bunch of clients that do this regularly. Same thing for jewelry. Those things are protected as copyrights. So take advantage of that. Same thing for packaging. In addition to getting design patents, you could also do copyrights on the packaging itself, especially if it has photographs on it, has artwork. It's also very easy to enforce on Amazon. We had somebody that was having a big problem with infringement issues with listing hijackers, and getting the copyrights, registering the copyrights on the packaging itself made a huge difference in getting rid of those infringers. Some things to keep in mind, as I said, make sure that you have all the rights at the time you create things, at the time a photographer takes the pictures, get the rights ahead of time. Registering copyrights, as I said, is fairly straightforward. If you're computer savvy, you could probably figure out how to do it yourself. If not, you have a lawyer do it for a small amount of money. It's very quick. Usually 6 months, you get your registration certificate. And the Copyright Office is unlike the Patent and Trademark Office. They do not really examine the applications in great detail. They tend to just allow them. Now that we sort of have this portfolio built up, how do you deal with listing hijackers? People call us and they say somebody is hijacking their listing. That really falls into 3 different categories. In some cases, people are trying to sell genuine goods on your listing, and you just don't like it because you want to have more control over who sells, you want to be able to maintain a pricing, and there's lots of different ways to deal with that. You can try to control who buys your products using contracts. One of the simplest ways is simply to have some sort of unique packaging that you used to sell on Amazon. Let's say, for example, you sell on Amazon, you sell in retail stores, you have distinct packaging just for Amazon sales. That way, if somebody's buying cheap in a retail store on sale or something, they can't go and flip it on Amazon because it's going to look because it has different packaging. You can easily be able to remove them for selling products that are not as described, that don't match the listing. So not enough people take advantage of that. It's relatively simple. And one thing you could definitely do, you can add pictures of your actual packaging to your listing. A lot of people aren't doing that. And a hijacker will go on and they'll see, oh, it just shows a product, mine's pretty similar, I'll put it there. But if you add pictures of your packaging, that's another step that the hijacker is going to have to get past. And again, we've had a lot of success in those situations, just taking people off, reporting them using the brand registry tool as selling not as described. Usually within a day or two, they're gone. The second category is counterfeits. You understand that's just a straight knockoff. Somebody's replicating your product, or they're reusing your copyrighted materials. Amazon certainly takes aggressive action on that. But again, even that is much easier if you have the registrations in place. The third category is what we call generic products. And this also, we have had a lot of clients with these issues. Where sort of the one on the left is actually our client, and he was having problems with people selling generic ones on his listing, generic phone mounts. And the way that ultimately we dealt with that permanently was by showing that, doing test orders, taking the photographs, and reporting them as not as described, and that provided the most consistent way to take off the hijackers. And eventually they got the message and they moved on. That's all I got. Any questions? I know I just dumped a lot on you. Go for it.
You said copyright can be filed at any time. So is there a risk that if there's something that's pointless sculpture, that you could risk losing out whether it's your own product or moving your
It depends. I mean, if you sort of have to prove ownership at some point. I mean, anybody can go and file a copyright. It said the Copyright Office is not going to do an extensive examination of who this was, and at some point though, if you went to enforce it in a court at least, you would have to prove that you did actually create it and it's not somebody else's. But at the same time, you could have copyrights, based on if you have what we call derivative work. If you were to take somebody else's sculpture and do your own version of it, you could have your own copyrights in that. So, no, there's no time frame. The point is, for what it costs and the amount of effort it takes, there's just no reason not to register right away. One other thing you can do about copyright registrations is that if you register it before you publish it, before you print it in a book, before you display it, you can actually register a whole collection at once. So this is very valuable for photographs. Let's say a photographer does the photo shoot. Right away, if they go ahead and file a copyright application, they can do the entire spread, the whole photo shoot in one shot, pay one registration fee, and they call it a collection. If they wait until after they've published, they would have to file separate registrations for each photograph, which gets cumbersome and it costs a bunch of money. Does that?
Yeah, that does. And then follow up generally on patents and copyrights in general. How does international law play into it? So if someone comes up with an idea in a foreign country, how does U.S. law interact?
Well, copyright is essentially global. Wherever wherever you develop the copyright, wherever you first put it into some sort of they call tangible medium, it's copyrighted. So you can register it anywhere. Patents though are territorial. So if you file your copyrights, your patent application in the United States, you only have rights in the United States. If you want rights in other countries, you have to go around and file in each country. There are certain ways to do that. There are PCT applications. There's ways to do it, but at the end of the day, you need rights in every single country if you want to enforce it there. Yes. Right. It will deter some people. Some people will look at it. They'll say, "Oh, this guy he's filed patents. He seems to be patent savvy. I'm safer just to stay away." Right. No. Until you actually have a registration issued, you have no patent rights. Yeah, look, if you were making your product before they ever came to it, then their patent's going to be invalid. But yeah, patent pending doesn't mean a whole lot. But people, again, it just depends on your particular industry, and it will deter some people. Yes. There's only one very, very limited circumstance. There's where with utility patents, after they've published, it's possible to get some sort of provisional rights. It's a very limited circumstances. The general answer is no. It's until they have the registration, there's no damages to worry about. Yeah, they were always. That's the requirement. You need a federal registration, principal register. Anybody else? Yes. Well, it depends. I mean, you can file on the brand overall. Let's say Toyota is the name of the company, but you're also going to have trademarks on all the different models they make, on the Camry, on the Highlander. Those are all separate. So you can have different types of trademarks. As long as it's something that designates the source of the product, where it came from, it could be subject to trademark law. So yes, it could be the sort of overall name of your company, and it could be all the sub-products along the way. Well, they can have their own trademark. Sure, they can private label the same way you do. So there's nothing wrong. Trademark doesn't really cover the product. It covers the name of the company behind it, the source. Well, again, if it's got the brand somewhere on it, you can't do that. I mean, yes, it should be. No, the origin of the product does it. As long as they're putting their brand on the listing or on the product or on the packaging, then they should have their own listing. And you shouldn't be on that listing unless you're selling that same brand. Well, sometimes Amazon gives bad advice. Yeah. Yeah, no system is perfect. Yeah, you shouldn't be on the listing. Well, you can go after those who are breaking the distribution agreements, right? You can set those people are, violating contract law. Right. So the correct way to do that is to try to distinguish, as I said, try to distinguish what you're selling online versus what gets sold in retail stores. That's, I think, the safest way, the most kosher way of doing this. You'll see a lot of, bad actors that will, file fake reports and say you're selling, counterfeits and things like that. I think the safest way is to distinguish the products, and find a way. Let's say, I don't know what kind of products these are. Let's say if you're selling cosmetics or something like that, you could have online I only sell the 1.2 ounce, but in stores I sell the 1 ounce. And that way you control the listings. You have brand registry. You only sell the 1.2. That way the people buying it in stores, they can't list against your listing. You could distinguish the packaging for clothing. That would make sense. Yeah, instead of, let's say, what you're selling online could have some very simple packaging, just poly or whatever, and then maybe what you're selling in stores has some different packaging or more ornate hang tag to get people's attention, where you don't really need that on Amazon. So then you take those pictures, you put them clearly in the listing. Somebody tries to list against you, at least you have a good argument that it doesn't match. Anybody else? You in the back? Nothing? Well, as soon as you file something, an application, it's patent pending. You can file a provisional application for very little cost and putting very little inside of it. You could write up a one page and just with one picture file. What? So that would be, you can do that for a year, and then you could just keep refiling provisional applications for $50, and you can keep it going forever. But I didn't tell you that. Other questions? You can report that. Sometimes they'll take it off, sometimes they won't. If you have if you have a registered mark, it'll help. They shouldn't be doing that either, because it's a form of infringement. Sure. Okay. I think we're done. Thank you all very much for coming. Appreciate it.